Welcome out to our legislative review for February 3rd, 2026. We are following up on some discussions, but continuing to review bills proposed by the legislature. And we have a number of bills we're looking at related to the judicial branch. The courts and the legislature have kind of come to heads here in Utah. The legislature is pretty upset at the courts because the courts have, in the last little bit, pushed back on some of the things that the Utah government's doing. So I wanted to go through today and talk about some of the changes to checks and balances and things that we have that are proposed. First, though, before jumping into the courts, I did just want to point this one out. This is a change to child welfare situations that is, in a way, you could say, reducing checks and balances on the government. This bill, this is Child Welfare Modifications, SB 124, sponsored by Senator Luz Escamilla. And it is authorizing a juvenile court to issue what's called an investigative warrant. So they don't come out and arrest you based on this warrant, to my understanding. But it's a warrant that authorizes them to come into your home to investigate. If it says, if it appears to the juvenile court upon a verified petition, meaning someone signed something under oath, that's the same as recorded sworn testimony or an affidavit. It says that there is probable cause to believe that there's a credible threat to the child's health, safety, or welfare. It is necessary to view, examine, or interview the child to ensure the child's health, safety, or welfare. And the peace officer or child welfare caseworker has made diligent efforts to ensure the child's health, safety, or welfare, but has been unable or not permitted to view, examine, or interview the child. So this is a situation where they feel if there's concern to a child, there's not enough information to arrest a parent, but they want to come out and investigate. The concerns I have with this, there's a number of them. First, what is a threat to the child's health, safety, or welfare? Is this that they live in a home without stair rails? Is this that a child's parent isn't taking them in every year for their annual checkup? Is it that the child's depressed with the welfare, different things? There's not very many bounds around what could constitute health, safety, or welfare. And if the government's allowed to come into your house to interview your child, to view or examine your child, to just ensure the child's health, safety, or welfare, this really starts to go deep into the realm of the family and the parents. And it's not very difficult to get a investigative warrant under these standards. Someone just has to have reason to believe that, again, the health, safety, or welfare of the child's in danger. They can state a fact why. And then a government official can come into your home and investigate. And to me, this is, again, while promoted towards children and safety, I get that. But if you follow back, Utah had a child who was homeschooled and he died. His father or stepfather, someone abused him. And after that, people really pushed, and there's a push nationally to have a lot more oversight on homeschooling, access to the home of homeschoolers and things. And that bill in the last session didn't make it through. And so this bill doesn't expressly mention homeschooling, but it follows up on that that history, you could say. And this is just broad, but again, we can come and investigate if we feel there's a reason for the concern for the health, safety, or welfare of the child. And And I look at that and I just go, those words are so broad. Those words mean almost anything that it doesn't put many bounds or protections on our homes being a place that the government can't just come in. And I personally believe that interviews by government officials are detrimental to a child's health as well. If they're just there, if the kid has to stress that they're going to get taken away by the government, I think that these aren't things to throw in lightly, that we're necessarily improving the situation by sending a government official to come examine a home and look at things. And so I definitely am not a fan of bills like this that give the government quite a bit of power to invade the home, and that in some ways even make parents more of a helicopter parent than they are. I think if the government's regularly coming to your home and checking up on things, and maybe it's not regular, but if there's that threat that the government can come to your home and check up on things, I also think that will contribute to a lower birth rate overall. People will be more afraid to have children because they have to have everything look good, be good all the time. You can never have a bad day type thing. And the fear of a government official coming to your house and having the power to take your kids away if they determine that something's not right is a real threat, and it really impacts people. And I don't think that we should be blind to what that might do. So that one's here and proposed. It did make it out of the Senate committee. There were at least 3 people that voted against it, but 6 voted in favor of it in the committee. And so that will be heard by the Senate soon to be voted on, and then it will go to the House. So that one is moving. But going forward with other ones, we have just a quick one I thought was really interesting. I don't know if it will get anywhere or not, we'll see. But this is a proposal to amend the Utah Constitution to make it so that voters have more say in voting on tax increases or debt that the government's taking out. And so it's a, yeah, there's, you can, if you want to look through this one, sorry, I didn't mention it, HJR 20, sponsored by Representative, I don't know how to say her name, Auxier. But this bill, you know, I'm certainly curious how things like this shake out. If the state or a political subdivision cannot increase revenue through a new transfer tax, a new state real property tax, changes in tax rates, or impose multiple rates of income tax, they can't spend more than a certain amount, and it goes through, and then it says without voter approval. And they do give a few exceptions to it, but it is saying, you know, tax increases, additional spending, debt in most situations has to be submitted to the voters for approval. And the reason that I'm kind of interested to see how that goes is, one, I have seen voters approve additional taxes on their own. That happened here in Murray. They asked for voters to approve raising taxes to fund a bond to build some additional schooling, and voters, majority of voters approved that. But I do know that many of the tax increases that government faces would probably not go through if voters didn't approve it. And that might be a good thing. Maybe it gives us some checks and balances. Maybe we spend a lot less money. But it is, and you know, maybe things get bad before voters approve a tax increase. But what I've seen start to happen with the political games that get played, if there are limitations like this, then we start to vote to cut services that matter most. So for example, one of the ways that the Park Service was protesting cuts to its budget when Trump first took office is they stopped paying to empty the porta potties. and then people didn't have anywhere to use the restroom. And so cities can make decisions like that. They say, well, if we don't get to increase taxes, we'll cut services where it hurts most so that people will authorize it. So it tends to set off an interesting political game if they can't get everything they want. But that can also make people upset. Maybe they get kicked out of office. I don't know. But I am curious to see how something like this would go. I'm curious if any of you have thoughts on what might happen if the cities couldn't decide for themselves to increase tax rates if everything had to go to voters. And I think some ways we don't fully know. But this bill is currently sitting in the House Rules Committee. It was just barely introduced yesterday. So it'll be interesting to see if it gets out of the House Rules Committee and assigned to a committee for a hearing or not. But yeah, but feel free to jump in if you have something. Since I'm sharing my screen, I can't always see people. If you raise your hand or comment, I don't always see that. So just feel free to jump in if you have a comment. But going to the checks and balances on the courts that we talked about a little bit at the start. There's a fair number of bills we're going to go through looking at court provisions. So the first is HJR 5. It's a proposal to amend the Utah Constitution. And this is on how judges are nominated. So it essentially, there's currently, and this has been getting whittled down over time, but there's currently a judicial nominating commission that goes through and reviews candidates for judgeships. Essentially, attorneys can apply to be a judge. And they look through them all. They determine who they think are the most qualified. In theory, they're probably looking at other things as well. But they then send a list of 5 nominees to the governor. In the past, the governor had to choose from one of those 5, and then that'd be confirmed by the Senate. There were changes they were making to try and make it so that the governor had more control over who was on this judicial nominating commission. And now this proposal is to make it so that the judicial nominating commission still sends a list of nominees, but the governor is authorized to appoint any qualified candidate, even if the candidate is not nominated by the nominating commission. So we're essentially making the judicial nominating commission kind of just a cute thing that's there. It removes a time constraint on the governor to make an appointment. So one of the plays the governor can do can just leave a seat vacant. And they're removing the authority of the Chief Justice of the Supreme Court to fill the vacancy if the governor doesn't. So they are trying to give the governor way more control to just appoint anybody, even if they weren't recommended or reviewed by a commission of additional people. So that one, if it goes through, will end up on our ballot to vote on in 2026. So we may have some of these to vote on. And if you have thoughts on any of these or comments, feel free to jump in and share those. This is another proposal to amend the Constitution on judicial retention. And this specifically is saying that the legislature can call for a special retention election to determine if a particular judge that engages in certain conduct can be retained. Essentially what this would do is if a judge does something the legislature doesn't like, if they determine that the judge is unfit or incompetent, persistently fails to make timely decisions in a case, or has engaged in conduct that violates the judge's oath or office, is improper, or creates an appearance of impropriety. It's a pretty loose standard. The legislature may initiate a process for the judge to be subject to a special retention election as soon as practicable. So this would mean that you're the one judge called out, and suddenly all of Utah knows a special election has been called just for you, a special retention election, I should say. And that one judge is going to be on the ballot, labeled as kind of the black sheep that the legislature doesn't want anymore, and put it up to the people. And even if you win that special retention election as a judge, you still have your vote come up later in your usual cycle if the if the people want to retain you or not. And the legislature can initiate this process even if the judge could be liable for impeachment, which means essentially the legislature is a little too afraid to impeach themselves, and so they're going to kind of drag the judge through the mud with this special retention election. My perspective on this is that this will certainly give a lot of political power over the courts to the legislature, because if a judge now goes against the legislature, they could easily lose their job. And I think it will produce far less independent decisions, far more politically charged decisions from the courts, if they have this always hanging in the back of their mind, and if this is one of the tools available to the legislature.
It essentially eliminates you have the judicial, the legislature, and the executive. It basically combining judicial and legislative together and eliminates that third check.
It really does. The Utah Bar is very opposed to this. They're actually quite opposed to a fair number of things, which, the Utah Bar is not always, I'd say, the guide on everything. But there is high concern among the legal profession because, if you have a case and, if you're challenging an unconstitutional law, there's one thing you know about that law. There was enough people in the legislature that supported it that it became law. And one of the important checks and balances for a long time in American history has been the ability to have something that checks the legislature. But if a judge now strikes down a law as unconstitutional, the legislature liked, and then they're suddenly subject to this retention vote, put up to a vote of the people, judges don't have the money to campaign on their behalf, to explain the nuances of the law, to explain everything to the people. They've never been built for that. It's not part of what they do. And I don't know if it's something we want them to be doing necessarily. But this is a proposal. This one, it's interesting. It's been out longer than the other one, but it's also sitting in House Rules Committee. And one of my concerns watching how long it's sitting there, and now Rules Committee is the committee that assigns it to other committees, and then it's heard in the second assigned committee. There's one of two things. They're either holding it here because they don't want to let it out, or they're waiting until later in the session when they suspend rules and just rush things through very quickly. And so I think it'll be interesting to see what happens with both of these. But it's ones that you may want to reach out to your reps on. Let them know if you have concerns, or really encourage them to vote no, but try and engage on discussions on those. This one, though, I think is a very good check and balance on the courts. I don't think that all the proposals are bad necessarily. And so I wanted to throw this one out. This is HB 397, Courtroom Audio Visual Modifications. And it's sponsored by Representative Mike Kohler. We currently, in some jurisdictions, you can access the court live streams, because courts, according to the Constitution, are supposed to be open to the public in general. They feel the founders felt pretty strongly it was part of keeping a good check on the court was just to have the public be able to view what goes on there, because then judges have to act a little bit better. If you have a judge that suddenly blows up and screams at someone or throws someone in jail for no reason, and you have a recording of it and it can be shared, then that I think is a proper use of scrutiny or oversight on the courts. It keeps judges more in line when there's cameras in the room. Judges aren't immune to feeling like they have a lot of power and are kind of untouchable. And so the public perception was necessary, and the founders also felt it was necessary for a public record to exist so that things could be evaluated and determine if it was going correctly or not. So this bill does work to create that, and also tells them to keep a recording of the live stream so that people can go back and look at things, that they can request things if needed. And there are other states that do things like this. And I think it would be a very healthy thing for Utah to start doing as well. But also looking at this one, it's sitting in House Rules Committee. This one hasn't been there quite as long. I know there has been resistance in Utah to this before, but I'm hoping that with the legislature wanting to clean up the court some, that this one can go through, but that they can also listen to some of the concerns on the other amendments that are being proposed. This one goes, it kind of makes me laugh. Our courts, or not our courts, our legislature is being a little paternalistic, perhaps, but maybe a bit threatening to the judges as well. The goal of this one is to change the percent required in a retention election. So all judges in Utah come up for a retention election to ask if they should be retained. So Utahns can get rid of a judge if a judge goes too far out of bounds. So far in Utah, we really don't kick judges out. They usually overwhelmingly win re-election. And so even some really, really bad judges that should have been kicked out in a retention election weren't. And Utah tried to address some information about judges. It created the Evaluation Commission, and they'll publicly list whether a judge should be retained or not based on their recommendation. They're usually quite deferential to judges, but that commission itself has recommended not retaining judges that were just doing very poorly. And people still voted to retain those judges. So this is proposing to say, you know what, instead of just a mere 50%, we're going to make it so judges have to get 67% of the vote to stay in office. And I was thinking about this with elected officials, and I thought, well, what if we make it so that an elected official can't win a second term unless they get 67% of the vote too? Just make it across the board. Once you're in, you get to serve your term, but if you've done a poor job and you can't get 67% of the vote as an incumbent, then you don't get to come back. But I'm not a fan necessarily of just focusing on judges. And I get that Utahns don't know a lot about them, but the information is there. And the 67% to me is a fairly high threshold that could be difficult. And if we just put that burden on the judges alone, not on the rest of the government, to me, it's still a potentially improper attack on the courts. But maybe we need it. Maybe we just are so dumb as Utahns that we can't figure out what to do with judges. So we need to increase it to 67%. I don't know if any of you have thoughts on that. This is HB 262, sponsored by Jason Kyle. HB 366, sponsored by Representative Tusher. This bill, we talked a little bit about this in another review when we were talking about the we're talking about the number of district court judges, whether people could choose what judges they ended up in front of. And so this is talking about requiring that municipal cases, which is a city criminal case, be assigned to one judge. They could choose two if they wanted, or three, because it says at least one. But that city is going to get an assigned judge. And they do put a max on it, though, where you can't have 10 judges assigned or just all judges assigned, because they want it to be based on a judge basically has to hear at least 500 cases if they're going to assign more than one judge to it. So if a city doesn't file more than 500 cases, it will only appear in front of one judge for those criminal cases. And we'll talk about this some. We have another one, bill, that touches on this as well. But there are pros and cons to assigning one judge to handle all types of a particular case. And we do this currently with different things. We currently say, for example, there's a landlord-tenant calendar, and we assign just a handful of judges to the landlord-tenant calendar. And they just get really used to landlord-tenant law, and they hear all those disputes. Or ones for debt collection, credit card collection, for example, they'll assign those to just a handful of judges that go through and do all those. And the potential benefit or con to that is, one, a judge can become very knowledgeable and experienced in one area of law and make really good decisions in theory if they know that area super well and they're not trying to do a case in legal area X and then legal area Y, then legal area B, just kind of all over the place. But the other thing that starts to happen is if the credit card company appears in front of the same judge every single time, one of two things can happen. One, the judge may really start to dislike the credit card company's representative, and they start to lose just based on the fact that the judge doesn't like them. Or they start to really like the representative, and they just get used to them and have a really good buddy-buddy relationship, and due process starts to slide. And so here you have the same prosecutors essentially appearing in front of the same judge over and over and over again. A lot of the same defense attorneys appearing in front of the same judge, not getting to rotate through, and that. And what happens from a criminal defense perspective, it's been really interesting to me as I've worked to help people that have been charged with a crime but have a constitutional defense to it. Some have some very strong constitutional defenses that I've worked with. And we try and find a criminal defense attorney that's willing to take the case and argue the constitutional defense. They're always willing to take the case and argue on facts, but very few are willing to take the constitutional defense. And as I've looked at it, I don't know for sure if this is the reason or not. No one's specifically told me this. But a criminal defense attorney generally is trying to secure as many plea deals as possible for their clients. They tend to get better plea deals if they have good working relations with the prosecutor and with the judges. If they have a poor working relationship with them, then the prosecutor can be less inclined to give as good a deals. And I've seen this with clients where on the criminal defense side, I say, what you need to look for in a criminal defense attorney is someone that knows the prosecutors and judges well, so they can get you a better plea deal or outcome. And that's kind of a fact of human life. If you know someone, you trust them more, you tend to kind of break more. But this, to me, seems to really facilitate that and kind of create a lot stronger of a good old boys network, you could say, where everyone knows everyone when they walk into court. I don't know if you're charged with a crime, if you want to be walking into a court where the judge knows the prosecutor perfectly, the criminal defense attorney perfectly, and you're going, does he like my criminal defense attorney or not? Because that could start to influence things. And again, hopefully judges don't have any of that bias. Hopefully they can look through that. But I'm not so sure. And things like this concern me because I think there is some benefit to random assignment of cases and having the chance to appear in front of a different judge. Because if you're an attorney as well and you're always appearing in front of one judge and your livelihood depends on it, you're probably not going to take positions that could benefit your client that might jeopardize your reputation in front of that judge. So for example, if you're an attorney and you file a case in another state and you'll never see that judge again, you'll take very aggressive positions because you're not concerned about the backlash to your reputation. But if your work is consistently reputation-based among the courts, your independence as an attorney starts to become threatened, I think, as well. So it's one to think about with changes like this, where they say, well, it's for efficiency, it makes things more experienced, it makes it all better. And I look at things and say, well, checks and balances is not about efficiency necessarily. We're concerned that power accumulates. And one of the keys I would recommend being aware of is that the most efficient systems tend to be the most tyrannical. Tyranny is very efficient. One person makes all the decisions. You don't have to go through processes. You don't have to go through bureaucracy. But we chose something different. And I'm not saying that government should take forever on everything. You should be able to get a driver's license without taking years. So if there are some places to talk about efficiency, but when we're talking about efficiency on necessary checks and balances, I do get concerned. And I don't believe that efficiency is in and of itself a virtue that we should just worship in government, because there should be things that slow down the process to keep checks and balances healthy. But to follow up, this one goes much more specifically. This one's proposing the creation of a new court, a constitutional court in Utah that is the sole court that hears constitutional challenges in Utah. So this one is HB 392, sponsored by Representative McPherson. And it would put 3 judges on this constitutional court. And so we have 3 judges that would essentially be the constitutional experts for Utah that hear all constitutional challenges. And if you couple this bill with, let's see, on judicial retention, if you engage in certain misconduct as a judge, and we're going to consistently put every single court case, constitutional court case, in front of 3 judges, those 3 judges will have super high pressure to not rule in a way that gets them subject to a retention vote. But it also removes from all the other judges out there the ability to make a decision on constitutional issues. Now, some people, again, may say, well, that's a good thing because not all judges understand the Utah Constitution. And there's certainly nothing about becoming a judge that guarantees you have a deep knowledge of it. You could have practiced in something that never touched constitutional law. And so there's that says, we have need for people that understand it. We'll put our best experts on there. But I think the concern becomes, well, who then are making the decisions and what are they subject to with this? And so these judges, presumably with the appointment, would be appointed by the governor. And so it talks about some of the things here. It says it has exclusive jurisdiction where a party is challenging the constitutionality of a state law. And so it does talk about being appointed and confirmed to the Constitutional Court. So this would be the governor appoints, the Senate confirms. They can be an existing district court judge or an existing appellate court judge. The judge can serve in both courts, so they can still do their day job and take up the constitutional challenges as they come up, because there's probably not anywhere near enough work to keep the constitutional court judges busy full time. But so they would convene at certain times, and then it says that if one of the judges can't convene when all three of them are supposed to be there, that the courts can have a pool of 3 judges that they then pull from to fill the vacancy, and they say randomly pull from. But they get to choose who the pool is for the 3 judges. So there'll be 3 kind of backups selected, and then if a judge can't make the one constitutional trial or hearing, then they can pull from one of those 3 judges in the pool. Utah, 2 years ago, I think, if I remember right, created what's called the Business and Chancery Court. We talked about it in another previous legislative review, where again the theory was, let's start to put business cases in front of 2 judges that know business law really well. But I look at that still as an attorney and I go, that's really starting to impact the willingness of an attorney to take on certain claims or arguments when they could lose reputation in front of one of those 2 judges. Again, right now, if you file a case in Salt Lake County, you get one of 33 judges. You're more willing potentially to do something that the judges don't like. And I'm not saying in a bad way, but there are some claims you can push that make a judge's life very difficult, and because they have to make a decision on it. And I've had this situation openly in court where a judge called us in and said, hey, I really don't want to rule on this. These are very difficult questions. I highly encourage you to go figure out a resolution to these. And that was to both attorneys on both sides. The judge says, you need to go figure out a resolution because I really don't want to rule on these. And I know that judges, experience pressure, experience a lot of things as well. They're human. And so, again, if you're an attorney and you're going to make a claim that makes it so the judge has to kind of go out on a limb to rule on something that others haven't ruled on, judges don't always like that. And they don't always like attorneys that really push them to make decisions on difficult questions. And so these are things, again, that I think your access and your ability to have redress of grievances goes down as we start to create courts like this or do things like this. But I'm curious if any of you have comments or thoughts, other things you wanted to bring up with some of these. This one, a lot of people have talked about for quite a few years, and it's interesting to see that there is a proposal for it. HJR 3, Representative Nelson Abbott is proposing to put term limits on Utah state politicians. So this wouldn't affect federal level people, because that would be a federal issue, not a state one. But state ones, he's saying, let's make it so they can't serve more than 8 years in the same house. So they could jump from, they could jump from the House of Representatives to the Senate, or the Senate to the governor. And this is specifically, I guess, talking about legislature here. And so it's proposing to put term limits on the legislature for the 8 years. Let's see. So that's a proposal to say we're capped at 8 years. His bill has been out. It's been public since December 30th. It's moved very slowly, and it's still sitting in House Rules Committee, not dispersed. This is one I kind of doubt they're waiting on for the last minute to try and rush through. This would be one I'd be surprised if Rules ever sends it on for consideration, or they wait till the end to send it on. I'm sure that a lot of representatives don't like this proposal, but I do applaud Nelson Abbott for bringing that one up. Applaud in the sense of it's an unpopular thing for a representative to raise. There's two sides to the term limit equation. There are some interesting arguments about whether it will actually help with what we're trying to do, or whether it will clean up government, or whether it will make it worse. Because one of the potential things it does is it might make it so that reps rely more heavily on the administrative staff that are not elected. If there's always new people and a lot of the legislatures being replaced at any given moment, the staff that's up there, the support staff, the managers, the admins, start to have a lot more sway in telling people what's happening and what's not happening, guiding the culture and things. And so it's possible it takes it some from the hands of our elected officials deciding what's happening to the administrative side deciding more. But it can also make it so that with the long time, powerful ones, there's a way to move on from them and have others come in. And so that's one. Term limits are discussed often again, and there's a proposal for it. So if you like that proposal, you would need to really reach out to the House Rules Committee and encourage them to hear that. If you want to find the committees and who makes those committees up, you can go to the committees tab up here, and they'll go through and tell you. If you go to all committees, you can find the Rules Committee, the House Rules Committee specifically, and it will tell you the reps, and you can email them if you're trying to reach a whole committee. This one is a current resolution addressing the national debt. It's one, it doesn't necessarily change anything because the state doesn't have the power to dictate what the federal government does. But it does go and say that we are very concerned, both from the perspective of a threat to our economy and national security, and that we want the government to start to balance the budget, stop growing the debt. And so they're asking, if this goes through, that it be sent to the leaders of the US Senate, the leaders of the US House of Representatives, and the members of Utah's congressional delegation. It was interesting to me that they did not resolve to send this to the president. And that they've been very specific in here, not directly blaming the president for any spending or debt. And they said that this deficit was from Congress failing to pass a balanced budget. And again, this is politics, but I think that they are concerned about offending President Trump. And so they're trying to place the blame on Congress and tell Congress to go do something about it. But I think Congress is also a little afraid to offend President Trump. And so I don't know fully if this will do anything or not, if we're not, specifically petitioning Trump to say, hey, let's pull the budget into control, let's stop spending. And so that's just there. Again, I certainly support Utah working to tell its reps to not go more into debt. But it does make me laugh a little because we'll pass resolutions like this, but then the state will take whatever money the feds offer them, even if it's increasing the debt. And we'll do things like bring the Olympics here and have more federal spending with that too. So I'm not sure that we're entirely cohesive in our messaging on debt. I wish that we would just say, yeah, we're gonna pass a resolution to stop taking federal money as much, reduce some of these things that we don't need. But this is a good first step potentially. But again, it's not binding. It's more a message, maybe political posturing. This one though, I really like this one as a check and balance on government. I've been talking for a little while now about the need to have some disclosure. And I would promote more disclosure than this bill does, but I think this is a really good step. Currently, if there's a bill that's been proposed, we often don't know who really was behind it. We have the face of the rep that's sponsoring it, but most of these reps didn't think of it themselves. It came from someone else. And so what he's proposing here is if a government agency was the one that approached a rep and said, hey, I want you to run this bill, or will you run this bill for us? Then they're at least saying, well, let's make it so that we know government entities requesting this. And you have to at least say the sponsor, it says, shall verbally disclose the nature of the request when presenting the legislation. So at a minimum, they'll say something quickly, and you'd have to be listening, I guess, to the hearing to know that, or have AI pick it up if AI is listening to the hearing. I think the bill should disclose on them who requested the bill, so we get a better idea of what people are trying to accomplish and who's behind things. But I do think it'd be helpful to at least have, again, I'll take a step in the right direction. Let's at least have there be verbal disclosures. AI can pick this up often from these hearings and then create a written record of what's associated with the bill. And I think that'd be a helpful thing for Utah. So this would only affect the House, though. This is a House rules resolution. The Senate would have to do its own thing too to make that a rule in the Senate. But it's proposed in the House, and it's also sitting in rules waiting to be assigned or considered. So it's interesting how many of these are sitting there waiting for them to assign. This is one that, so I guess to give a little more context, Roe v. Wade was overturned by the US Supreme Court, and with that, states were given the power to regulate abortion in their state. And since then, it's been a very kind of fascinating mess and whole slew of differing results state by state. Some pass it legislatively pretty quickly. Courts put a stop on it. Some courts overturn it. Wyoming Supreme Court, for example, overturned Wyoming's abortion ban under their state constitution because Wyoming has a constitutional provision that says the individual has a right to make healthcare decisions for themselves. And so they felt that the Wyoming Supreme Court felt that the abortion ban violated that constitutional provision. Utah passed a ban as well. This is a second reason why the legislature is quite upset with the courts. But I view this as more one judge type situation than the courts in general. But the judge, people sued to claim that Utah's provision was invalid, that banned abortion, and the judge put Utah's provision on hold, but won't issue a decision in the case. And so this is one that I think that he'd probably be the first judge submitted if there was a special retention election passed. He'd be the first judge submitted to say, hey, Utah, let's not retain him, get him out because he won't make decisions on the abortion case. And we're just sitting here now for, I don't know, 3 years or something, whatever it is, unable to enforce a state law. So with that background, they're still trying to find ways to deal with abortion. And this proposes to say that you lose eligibility as a Medicaid provider if the provider or the provider's affiliate performs an elective abortion and has annual revenue of 500 million or more. But then it's not applied to a hospital. And so I think it's a very targeted legislation towards probably just Planned Parenthood in the state. I don't know of others that would qualify under this. There might be. And I don't understand why, if this is an important thing, why we put the cap or the floor of 500 million on there. It's a pretty big organization. I don't know if we want to encourage a lot of smaller providers to come in that only make 400 million. Yeah, I'm not entirely sure of the reasoning with that, but it's interesting to say that they can't be eligible to receive Medicaid if they perform an elective abortion. And there will certainly be some constitutional issues with this. People argue about whether the state has the power to fully determine who's eligible for Medicaid, if they can impose additional requirements. And there is some, Medicaid did give the state some power to determine eligibility under the Medicaid program. And so I'm not sure exactly, I'm not a Medicaid expert. I don't know exactly how that case would go. I'm just saying, though, that they would certainly file a lawsuit arguing the state can't regulate that. But there is at least something in place the state's already doing for Medicaid eligibility. And so it would be an interesting thing to see if they are able to shut down abortion through the funding side of things, at least the Planned Parenthood side of abortion. Because again, they exempted the hospitals from this. And this is HB 232, sponsored by Representative Nicolene Peck. If you have thoughts or concerns on that. And then we'll probably wrap up with this one because it's almost 1 o'clock. There's a lot of push on voting to clean up elections and things, and this is one that is pushing to make it so that to vote in a Utah state election, you have to show proof of US citizenship. And they are proposing to create a system that they call it bifurcates the ballot. So essentially, to be able to vote on the state ones, you have to be able to show something. On the federal ones, they're not changing anything because the state can't fully regulate federal elections. So they can't impose additional requirements on a federal election above what the federal government does. And so they're proposing essentially you get 2 ballots, or your ballot be in a way that they can require proof for one side of the ballot, but not the other side of the ballot. So your federal candidates are on the one side and your state candidates on the other paper. And so you may be able to vote in federal elections still without proof of citizenship if those bills don't go through. I know Representative Mike Lee has a bill pushing to prove US citizenship in federal elections as well. But if that doesn't make it through, then there would be the bifurcation essentially in place. So again, this is one that there's a fair amount of support for, but there's also a fair amount of opposition to. Some people believe that certain groups of people, even though they're here legally or citizens, they could be dissuaded from participating. They call it disenfranchising, where you don't have ready access to proof of citizenship, and it can interfere with your right to vote, they say. And back when I was in law school, a good 18 years ago, we were arguing about this ID requirement even back then. And we were supposed to argue both sides. And it was interesting to see the claims and the statistics of people that lack IDs. A lot of them are older, or some just never fully spoke the language. And again, some people are okay with that and say, well, if you don't speak English, maybe you shouldn't be voting because you don't understand what's going on. others are concerned about that. And so this bill is proposed, and its status is that it passed the House already, and it's been to the Senate, and it's currently in the Senate Judiciary, Law Enforcement, Criminal Justice Committee, so it could very well go through if the Senate committee approves that, and then if the Senate votes on that. So it's halfway through the process. So heads up there on HB 209, sponsored by Representative Malloy and Senator Winterton. So just before we wrap up today, are there any thoughts, questions, concerns, anything else anyone wants to raise? And if not, we will wrap this up for today and meet again next week on the 10th to go through some more things. And again, if you have bills or items you want to discuss or concerned about, just email me at ahepworth@believe.legal, and I can be prepared to talk about those as well. But thanks for joining today.
Thank you.
All the time.
Thank